Hi, I'm Tom Bradford. How can you stay in the UK after you've been divorced? How does this affect your immigration status? Well, I'm going to explain what the position is with reference to the legislation, which we'll go through in a minute. But essentially, if you're married to an EU national or a British national exercising EU treaty rights in the UK, then it's possible for you to stay on in the UK and secure settled status, permanent residence later on. You need to show that you have retained rights of residence, and there's specific rules about your marriage and how long you need to have been here. So let's go through it. So what you would fall under or look to fall under is this definition of a family member who has retained rights of residence under Appendix EU of the immigration rules. Now I'll just zoom in here. And before going into the detail of what this provides, I'm just going to give you an overview. So the important thing here is your decree absolute rather than the decree nisi, which represents the beginning of the divorce proceedings. As a matter of law, you're deemed to be married right up until the decree absolute. The important thing and the first point is that when your decree absolute is issued, you need to be resident in the UK. So it's very important that you do that, even if you've already broken up with your partner and living elsewhere. You should be remain resident in the UK. And then you've got to show you either were married for 3 years or more and you were continuously resident in the UK for a year. So you've got to have been married for 3 years or more and have got to have been continuously resident in the UK for a year. And your partner would need to have been working, studying or financially self-sufficient during this year. It's actually not a requirement under the new EU settlement scheme to show that they were exercising treaty rights, but I think it's cautious. I think the cautious approach would be to show that they were exercising treaty rights at the moment, particularly pre-Brexit. Now, the next way of showing that you have retained rights of residence, this is if you can't satisfy that 3-year rule or the 1-year rule, is that you show you have custody of the child of your partner. And the third way that you can show you have retained rights of residence is if you have a right of access to the child with a court order, and the court order has actually got to state that that access to the child must take place in the UK. Now, as for your immigration status, that would be that of a family member who has a retained right of residence. Now, if you already have a biometric residence permit, which states pre-settled status on it, then you may not even need to be issued a new card. The Home Office will link that card to your new status as a matter of procedure, but you will need to make the application either online or through the app. Now, as for the legislation, I'm just going to show you the legal basis for all of that. So this is the law on this point is to be found in Appendix EU of the immigration rules. And there are in fact other ways, which I've grayed out here because they're not relevant for this video, but there are other ways of showing you have a retained right of residence. If, for example, your partner passes away, then there's separate provisions in relation to that. But when we look at the actual conclusion of a relationship or termination of a marriage, then these are the provisions. Let's just zoom in on them. So you, the applicant, referenced here as A, would be an EEA or non-EEA citizen, so this applies to both whether you're European or not. who ceased to be a family member of a relevant EEA citizen or of a qualifying British citizen, as I say, a British citizen exercising treaty rights, on the termination of the marriage or civil partnership. Number two, and sorry, I've skipped a bit here, but that bit here just says that you're deemed to have been in the relationship up to the point of actual termination, so degree absolute. Number two, that you are a resident in the UK at the date of the termination of the marriage or civil partnership. So that's something you have to manage carefully, especially if perhaps you might be staying with your parents after a relationship has fallen apart, out of the country. You've got to remain and be resident in the UK at the point of the termination on the date of the decree absolute. And then one of the following needs to apply. So option one here is it's lasted for 3 years and you've been resident for a continuous qualifying period in the UK of at least 1 year. So to just go over that again. Prior to the initiation of the proceedings for the termination of the marriage or civil partnership, the marriage or civil partnership had lasted for at least 3 years, and the parties to the marriage or civil partnership had been resident for a continuous qualifying period in the UK of at least 1 year during its duration. The law here is a bit clumsily worded, but you see the point there. So 3 years and resident for a continuous qualifying period in the UK of at least 1 year. That was while the relationship subsisted. And again, it's deemed to subsist up to the point of the decree absolute. Secondly, you have custody of a child of the relevant EEA citizen. And remember, this is either or, so satisfying any one of these options will be sufficient to show that you have retained rights of evidence. So you have custody of a child of the relevant EEA citizen or qualifying British citizen, or you have a right of access to the child and the court order specifies that the access must take place in the UK and that child is under the age of 18, or the continued right of residence in the UK so you in this case, is warranted by particularly difficult circumstances. I haven't touched on this because this doesn't come up often, but in cases where you or another family member had been the victim of domestic violence or abuse while the marriage or civil partnership was subsisting. So that wouldn't often come up, but if you don't satisfy any of these criteria, then there may still be a basis for you to apply to remain in the UK, particularly if there's children involved. So I hope that's helpful in highlighting what the legislation provides. This legislation is actually new at the point that I'm making this video, still relatively new, and so caseworkers in the Home Office aren't particularly confident in applying it. So I hope that is helpful, and my contact details are below. If you want to subscribe for more content on this and related topics, feel free to hit the subscribe button and click the notification bell. And I will see you in the next video. Thank you. Bye for now.